Today, we're diving into a story that shows how a pretty small rule break, listing a room for a short-term rental, spiraled into a huge legal battle with a massive bill attached. This is a wild one. Let's get into it. Seriously, how does this happen? How does a simple warning, a quick phone call, turn into thousands and thousands of dollars in legal demands? Well, as you're about to see, it all boils down to one very contentious phone call and a final, really sharp decision by a judge. So let's set the scene. Our story starts with the dream of a little vacation getaway in beautiful Sedona, Arizona. A family buys what they think is going to be their peaceful escape. Keywords, think is going to be. Okay, so here's the basic timeline, and these are the facts that nobody really disputes. In 2017, Mr. Stienstra buys the house. A few months later, his son, who's helping manage the place, lists some rooms on VRBO. Now, that was a clear violation of the HOA's 30-day rental minimum. No argument there. And that violation led to a phone call in April 2018 from the HOA president, and this, my friends, is where the two sides of the story just completely split apart. First, let's look at the HOA's side. According to the board president, Bill Ferguson, that call was not great. He later testified that he got the impression the homeowner was being difficult, that he wasn't going to comply, and that he had to just keep repeating the same thing over and over, shut it down. But here's the thing. The homeowner remembers that exact same call in a totally different light. He testified that he immediately said, "Oh, my mistake," agreed to comply, and hung up to call his son right away to take the listings down. So right from the jump, we have two completely opposite accounts of the same conversation.
So you've got this classic he said situation over a phone call. How on earth did that escalate into a formal and very expensive legal war? Let's take a look.
Well, the HOA board, operating on their belief that Mr. Stienstra wasn't cooperating, decided to take the next step. They brought in the big guns. They hired their law firm. And that decision, right there, changed the entire game.
And boom, on May 11th, the first official letter lands. It's a classic cease and desist from the lawyers, formally demanding that he stop all the short-term rentals.
Now, the homeowner insists he'd already shut it down after that first phone call. But the HOA wasn't convinced. They saw one of the VRBO listings was still technically online. You couldn't book it, but it was there, and they took that as proof he was lying. So less than a month later, they sent another letter. And this is where things get really painful. That second letter came with a brand new demand. You owe us $1,500. That was to cover the attorney's fees they'd already spent just trying to get him to comply. But it wasn't over. Not by a long shot. The HOA then found a new Facebook Marketplace post from the son, this time offering parts of the house for monthly rentals, which was also a violation. So you guessed it, here comes a third demand letter. And with that third letter, the demand for attorney's fees shot up again, this time to $2,600. You can see how fast this is spiraling, right? In just a few months, a simple, "Hey, you can't do that," turned into a pretty hefty financial demand. This quote from the court documents tells you everything you need to know. At one point, a board member was asked, "Hey, maybe if you just called the guy, you could have cleared this all up," and this was his response. It just shows a complete and total breakdown of trust. The board had already decided they couldn't believe a word the homeowner said. Now, here's the really interesting twist. This whole legal fight didn't end up being about whether the homeowner broke the rules. I mean, he clearly did, and he admitted it. The entire case came down to a much more technical question. Which set of rules was the HOA supposed to follow to enforce their own policy? So anyone who lives in a planned community knows about the CC&Rs. It's basically the constitution for your neighborhood. And this is so important because a ton of HOA disputes are about whether the board followed its own rule book correctly. In this case, that playbook had two totally different ways the HOA could have played this. Okay, so check this out. On the left, you've got what we can call the due process path. This is the standard procedure. Send a written notice, give the owner a chance to come talk to the board, give them time to fix it, then you can levy fines. On the right, you've got a different, more specific path for leasing violations. This one lets the HOA demand the owner deal with their non-compliant tenant, or in this case, the son. And if the owner fails to act, then the HOA can step in on the owner's behalf and bill them for the costs. So the HOA and their lawyers, they made a strategic call. They decided to use Section 1.1, the leasing path. Why? They testified they thought it would be faster, more expeditious, to solve the problem and get their legal fees paid. And that one decision, that turned out to be the mistake that unraveled their whole case. All right, time for the main event. After all the letters and all the demands, the case finally lands in front of an administrative law judge. Let's break down how she saw this whole thing.
The judge's logic here was just beautifully clear. Step 1, she looked at the evidence and concluded that yes, the homeowner did take action right after that first phone call. Step 2, she noted that the HOA chose to use Section 1.1. Step 3, and here's the killer move, she points out the mismatch. Section 1.1 is specifically for when an owner fails to act. But since this owner did act, the condition for using that rule was never met, which brings us to the big conclusion. The HOA never had the right to hire lawyers on the owner's behalf because the owner had already done what he was supposed to do.
And here it is, in the judge's own words from the final decision. Because the HOA used the wrong tool for the job, those legal fees they racked up, they just weren't valid under their own rules. So, after all the drama, the letters, the legal posturing, how much of that $2,600 was the homeowner ordered to pay the HOA? A big, fat zero. Nothing. In fact, the HOA was ordered to pay the homeowner back his $500 filing fee. Ouch. So, beyond this one messy fight in Sedona, what can we all take away from this? What are the bigger lessons here for any homeowner or any HOA board member for that matter?
I think this slide just nails it. First, for HOAs, procedure is everything. You have to follow your own rules to the letter. Second, get it in writing. This whole mess started with a phone call nobody could agree on. Third, try to de-escalate first. A simple follow-up call, as the judge said, could have saved everyone a lot of time and money. Both sides have to know their rights and what the rulebook actually says. And finally, and maybe this is the biggest lesson of all, distrust is incredibly expensive. The board's assumption they were being lied to directly led to thousands of dollars in wasted legal fees.
It's a fascinating case, right? It just shows how a few small missteps in communication and procedure can have these huge, expensive consequences. It really leaves you with a great question to think about. If you were on that board and you got the call about the VR below listing, what would you have done differently? Thanks for tuning in.